How do we balance the federal government's budget? What do we actually do to that? One of the options is proposed by an organization called the Convention of States, is for the states to take lead and to require an amendment to the federal Constitution requiring the Congress to propose balanced budgets. It's a real need. It needs a real solution. There's no doubt about it. There aren't many people I can think of who don't want the federal government to balance its budget, because we all know this is a cliff that we're going to fall off of, and we want to have it solved. The difficulty of the challenge I have is the method. You see, Article 5 of the U.S. Constitution allows two means for amendments to the Constitution to be proposed. The 27 amendments that we have right now were all proposed by Congress. That's how they were initiated. Then they go through the process of ultimately being ratified. And that's how they've all been done so far. There is another means, all right? And that's where the states actually initiate the process. It does sound appealing. And I think the founders, when they wrote this approach, they meant for the states to have this avenue. And it's what the states can do is apply for a convention. And if 2/3 of the states do, they actually come together. The states then have delegates come together, and they can go ahead and propose amendments to the U.S. Constitution that then get ratified by later processes. And that is, and the idea being from this private organization, the Convention of States, is that the federal government's never going to propose such an amendment. Congress isn't going to do that to themselves. They can pass a balanced budget anytime they want. They're just not going to do it. So the states need to impose it on them. Now, if you take a look at Article 5, okay, the language on it speaks in general terms, as does the rest of the Constitution. Okay, it just speaks in general terms. There's a lot of detail in there, such as delegate selection, okay, date and location, things like that. There's just a lot of detail that's not specified. Now, who specifies that? Okay, this is where I differ with the Convention of States. You see, they'll come along and propose the idea that, well, in order to make it safe, in order to contain this, so they just process certain specific topics. Now, they have three in mind, but I'm just going to speak in terms of one, the idea of a balanced budget. It's been a cornerstone topic of theirs for a long time. They'll develop the specific language that should be as a part of the amendment. Then they'll go to each state and say, pass a resolution saying, here's the exact language that this convention is to pass. And then restrict your delegates to that convention to just passing that language. And they can't do anything else. Prohibit them from doing anything else. They might even pass a separate law where making it a felony for a delegate to violate their own instructions. So the states can control their delegates to go down a specific avenue through the idea of these rules contained in a resolution, an actual bill if needed at a state capitol, okay, to control exactly what they do. Because who knows, you might get some delegate from New York or Illinois that just goes completely off the reservation and manage to get something through that would really harm our republic. Think about it. Not everybody thinks like Oklahoma, right? So they put on these safeguards. Okay. Now, there's a couple problems with that, because when we look at Article 5, we can't just look at the Constitution. We also have to look at how the courts have interpreted it in the years that follow. That weighs in. And I'll tell you right now, just in summary, the power of the states that I believe our founders intended, because of court decisions, has been given to Congress. Okay, it's been usurped. And it's just the way it is. So understand, it's not really to the benefit of the states. It's a gamble, it's a serious risk. And because of that, I suggest we don't pursue it. To get into these court decisions, you need a little bit of background. You need to understand what happened. At the last Constitutional Convention we had, 1787, that gave us our current Constitution. because that set the stage and the foundation for the court decisions that followed. If you were to go back and read some of the documents of the day, and one that I like to draw upon quite a bit is James Madison's notes. He was a delegate to the 1787 convention from Virginia, and he kept his own notes on what was going on. And the convention had its own minutes, and you could read those. I've read through them. But what Madison records, an interesting event that occurred during the convention. You see, when they first got together, they had their instructions from their states. All the delegates came together from the various states, all but one, Rhode Island. Rhode Island, they stayed out entirely. They said they just didn't want to participate, and they said, because we're not going to participate, whatever you pass, it's not going to go through. We're not going to get a new constitution or any changes. We're happy with the way it's at. Boy, did they ever, it didn't come through for them. Well, the whole idea of their instructions, I'll post this, you should see this on the screen. But they were to render the Constitution of the federal government adequate for the exigencies of the Union. That was generally the instructions given to the delegates in the various states. Now, notice this. It looks kind of broad, doesn't it? Hey, render the Constitution adequate. The federal government and the whole bit. Just take care of what you need to do. But here's the challenge, okay? And this is what the delegates faced. It's how they define the word federal. You see, they define the word federal different in that day than we do today. And they actually discussed this during the convention. See, for them, federal, a true federal government, which they had at that point before our current Constitution, it meant that all the member states were all sovereign, and that central government, what we want to call the federal government, they didn't have any powers. They could propose ideas, and then it was up to the member states to implement. It's much like how we might view the UN today. United Nations has no power on its own. It relies on its member states to implement whatever it proposes. That is how our nation first came together under our first Constitution, the Articles of Confederation. That's how we were operating. What they did was, and their instructions said, they had to keep this federal model. That was a requirement of the states. They were not to give any or all of their sovereign powers to the central government. The states were jealous guardians of their own power. Well, for the first few weeks, when the delegates got together, they actually tried to revise the Articles of Confederation, even develop a whole new constitution with the idea of the federal mandate. How do we stay in a federal structure? They took what they called the New Jersey Plan and began to work it. And they couldn't come up with anything that made them satisfied them. In the back of their mind, they had another plan they really did favor. It was called the Virginia Plan. And in that plan, what the states were to do is delegate some of their sovereign powers to the central government. Not all of them, but some of them. Okay, so now what they were proposing is this hybrid government. See, if 100% of the powers are at the central level, that is what they called a national government. Okay? If 100% is at the member state level, well, that central government is a federal government. We actually today have a blend between the two. That's what our Constitution is. We don't really have a federal government, even though we call it that. That name just carried on. We actually have a blend, a hybrid between the two. Well, to propose that was going to violate their instructions. Okay? So they had to consider that. Were they going to violate the instructions by their states? By the state legislators? Well, Madison was the one, James Madison. He was the one who gave them the rationale for doing exactly that. And he explains this in his notes. Okay? He said, he referred to the Declaration of Independence, I'm sorry. But what he said was, and you see this on your screen, he made this comment first. He said, the people were in fact the fountain of all power, and by resorting to them, all difficulties were gotten over. They could alter constitutions as they pleased. The whole idea is whatever they came out with needed to be approved by the people. If they were to just stay with the federal model, it could be approved by state legislators and it would work. But if they went direct to the people to get approval, okay, all right, that made it valid. That made it morally ethical. To draw support for that idea, he went to the Declaration of Independence, which says in part, whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute a new government. It does say that in our Declaration of Independence. And they assumed that power at that convention. And with that in mind, they stood up, delegates stood up, and they said, okay, we're going to violate our instructions. And even later on, when he had this new constitution, they spoke about in the various state assemblies when they got together, they had to justify why they violated their instructions. And we have a lot of quotes from founding members explaining exactly that, why they assumed the ability to violate their instructions. Now, so when they finally resolved that a few weeks in, they went ahead and proceeded to write an entirely new constitution. And they included in that an entirely new means of ratification. Okay, we're going to come back to that. Just understand, the delegates violated their instructions. Now, since then, okay, what we've had, and by the way, it took. Just realize that. It worked. That's what's key. The Convention of States will say that what I'm proposing is that the delegates did something that was illegal. It violated the law. No, not at all. It was very moral. Freedom of association is the natural law you appeal to. People can go ahead and rewrite their Constitution if they want to. We could do this today. That's a part of what scares me, okay? Based on the premise that the people have the right to alter or abolish their own form of government. Because that's what they did in 1787 at that convention. They proposed a whole new government, and the people passed it, people ratified it. Now, since then, a number of states have joined the Union, and they've had to write constitutions. They've had to alter state-level constitutions. And the matter has actually come up before the courts because some of the states would try to bind their delegates, including Oklahoma, by the way, in 1907. They would actually try to limit their delegates. And the state Supreme Court in Oklahoma, as well as others, said, no, you can't do that. You can't bind your own delegates. Basically, what they said is the delegates run around as free agents, okay? And there was so much, this happened so many times that the courts came out with a legal summary. I won't get into the whole Latin phrase, but the whole idea is, I'll put this on the screen, but you'll see it in bold. Their power, speaking of delegates to a convention, their power may not in any respect be limited or restrained by the legislator. Under this view, it is a legislative body of higher order and may not only frame, but may also enact and promulgate a constitution. So a convention is a legislative body of higher order. When the Oklahoma Supreme Court, and this is several state Supreme Courts making this decision based on what's going on in their states. Remember, the whole idea is states to be added to the Union have to come up with a constitution. They would go through this and finally come out with this legal summary. And even Oklahoma, the Oklahoma Supreme Court read that decision and said, look, we really have no involvement here. It's the convention proposes whatever it wants. It gets approved or denied by the people. And that's it. Then they begin to operate. That was basically their conclusion on that. So what the Convention of States wants to do is limit the delegates. There is a resolution passed at the state capitol right now where the state of Oklahoma has applied for a convention with the federal government, with Congress, and for the purpose of balanced budget amendment and a couple other things, and which, they're good causes, okay, don't get me wrong. But they're asking the states to constrain their delegates. and it's already been decided in court. They can't. Okay, and now what we have is this idea amongst legislators. The delegates go to a convention, they come out with something strange that violates their commissions. They come on back, and what are the state legislators going to do? Well, you violated the commission, you committed a felony, and it's time to take you to court and get you prosecuted. And you know what the courts are going to say in Oklahoma? This has already been decided. There's no way we can prosecute these delegates because it's already been established by precedents. They basically operate as free agents, to use my term. A challenge is not all our legislators know this, so we need to bring them up to speed on that. The safeguard of the Convention of States is not valid. It won't hold up. So it is wide open. And let me ask you something. Do you trust the New York and Illinois and California and what they might possibly propose at a convention? See, they may not stick with a balanced budget or term limits and whatever else the Convention of States wants. They have their own ideas. And they may win. They may dominate. Okay? Now, let's go to the next phase on this. There's another important court decision I want you to realize and be aware of that has a bearing on this. Remember, the Constitution speaks in general terms. What about the detail? Well, Supreme Court's actually already weighed in on this as well, the U.S. Supreme Court. In the, 1921, throughout our nation's history, periodically, the topic of having a federal level constitutional convention, Convention of States, Article 5 convention, choose your term, doesn't matter to me. That topic comes up periodically with cause throughout the ages, right? Oh, we have 250 years of history, right? And the Supreme Court has actually weighed in on it. And here's what they concluded, 1921. They made it very clear, and it makes sense. As a rule, the Constitution speaks in general terms, leaving Congress to deal with subsidiary matters of detail, as the public interest and changing conditions may require. And Article 5 is no exception to the rule. You know, Congress, when they implement laws, they need to be consistent with the Constitution. This is true of our own state legislature. It has to be consistent with the state constitution. The Constitution is supposed to speak in general terms. And our legislative body takes care of the detail. That's how it's meant to operate. And that is true for all areas of the Constitution. Think of the federal level now. It's even true at the state, but think of the federal. This is what the Supreme Court's saying. It's saying Article 5 is no different. So the whole idea of delegate selection, delegate count, delegate restrictions, whatever there might be. You see, Congress has a great deal of power. Where the states have been limited in their hands of tie, state legislators have been limited, their hands are tied behind their back, saying you can't limit your delegates. Well, guess what the U.S. Supreme Court said to Congress? Basically, you have free reign because the Article 5, you can take care of the matter of detail. And Congress has. If they want to, for example, the Convention of States proposes the idea of one state, one vote. It's in their name. It's not as they'll explain it, you look at the training material on their website, it's not a convention of delegates per se, okay? Is it a convention of states? So each state gets one vote. Now, do you know who that's appealing to? If each state is one vote, isn't that appealing to the small states? Yes, like Oklahoma. Because Oklahoma gets one vote, California gets one vote. How can they possibly dominate when I think how many state governments are controlled by Republican majorities? I think it's like 32, it may vary a little bit, but you get the idea. So wouldn't Republicans rule the roost? No, I'm not sure. In a matter of the Constitution, I'm not sure I trust Republicans much more than Democrats, but you get the idea. Okay, so it seems like a means of keeping it safe. But guess what? Congress has no appetite for that. Okay, last time we came close to having a convention, it was about 40 years ago. What was the topic? Balanced budget. Nixon had taken $1 off the gold standard, early 70s. Congress was spending money and the deficit was growing. It was in billions of dollars then. I know we got trillions today, but that's what they were looking at back then. States were applying for a convention, and they came close. Up to, 32 states had applied at that point in time. This is the 1980s-ish. Remember, it's a multi-year span, but that's the time frame. Well, they were getting close. So what Congress did was they floated 41 bills to regulate and to legislate that convention. Supreme Court already said that's their place. And you know one of the common topics that they had on in these bills? Now they sat in committees, okay? None of them passed both chambers and went into effect. They sat in committees. It only makes sense. Floor time is valuable, so they'd sit there and wait until 34 states had applied. Needed 34 states to apply. There were 32. But you know the most common topic, it was in here, one of the big ones, was delegate apportionment. The most common solution that they proposed was to base it on the Electoral College. If that's the case, it wouldn't be one state, one vote, like Convention of States is proposing now, okay? Oklahoma would get 7 votes. California would get 54, okay? And so on. You run around the states, look at Illinois and New York. That population becomes a factor because the Electoral College, you get 2 votes because you have 2 senators, and then the rest of the votes is based on how many how many federal representatives you have. Oklahoma, we have 5. So that's all of a sudden, it's very skewed. Now, can the states resist and say, no, wait a minute, we passed a resolution saying one state, one vote? No, it wouldn't hold. How many delegates do you think California would send to that convention? If we send 1 and California shows up with 54, is California going to object because Oklahoma sent 1? No, they're going to say, come on in. Come on in. The water's warm. So the whole thing is skewed. The city selection, all the other parameters, okay, that go around this convention. Congress would own it. If you take a look at some of the ideas they had and proposed back 40 years ago or so when they did this, they would own that convention. They would set the table. And we all know whoever makes the rules for any convention, you think of the Republican Party convention, the state convention, whoever sets the rules gets the results they want. That's how it works. And it would be the same way at this kind of a convention. And it's already been challenged, this idea, and the Supreme Court's already decided. Congress would utterly control how such a convention were to occur. So the founders may have had these novel ideas of giving the states an avenue for initiating convention. But these court decisions later on had deflected all this power to Congress. And frankly, the Convention of States is not addressing this. They actually tried to in Oklahoma. They came back with a rebuttal to this very presentation, and they gave it in a couple of counties. And kind of surprised me. I didn't know of it ahead of time. Even when I heard it, it was spoken of very quickly and it did refer to some court decisions. But I won't get into all those details. But those court decisions simply didn't carry water. I'm surprised that the Convention of States proposed them the way they did. They had lower courts trying to override Supreme Court decisions, the whole bit. But it was read so fast, people didn't have a chance to process it and digest it. Well, please, folks, I'm going to ask you not to support a Convention of States. Oh, by the way, one more thing. The ratification process, the ultimate safeguard, according to Article 5, got to bring out this detail before we close, is the whole idea that 3/4 of the states have to approve whatever comes out of a convention. They have to ratify it, is the term. And that's the ultimate safeguard. So New York and Illinois come out with some crazy ideas and actually get it through a convention. Well, we have this ultimate safeguard. 3/4 of states have to approve it. I know that's in the Constitution, but that too can be changed. Now, that may sound kind of strange. Bob, what you're saying is unconstitutional. Yeah, I know. I realize that. I realize what I'm saying. It may sound like strange fire. It seems kind of odd because I'm proposing the idea that a convention can actually violate the Constitution. And let me explain it. let's go back to 1787, when they gave us our current Constitution. The requirement placed on them when they went into that came out of the Articles of Confederation. They already had requirements they were supposed to meet. And that was, all states had to approve it. It had to be unanimous. Whatever they came up with had to be unanimously approved. Now remember when I brought up Rhode Island and they didn't even send delegates? They basically let the convention know, it doesn't matter what you come out with. You need unanimous approval of all the states, and we're going to immediately reject it. So you enjoy your tea and crumpets. I guess maybe they were having coffee then, right? You enjoy your tea and crumpets, and you meet in Philadelphia, and you do whatever you want. In the end, we're not going to approve it. It is going nowhere, okay? My paraphrase, right, what they said. What they did, now they were fully aware of this, okay? So what they did when they came up with this new Constitution, near the end of it, in the final days and all, they said, look, we need to come up with a whole new means of ratification. So they decided to violate the Articles of Confederation. When I say the word violate, that's actually their word. They use the word violate, okay? So they ignored the Articles of Confederation requirements of all 13 states unanimously passing it. And they came up with a new means of ratification, and they appended it to the end of our current Constitution. It's actually in our Constitution that we have now, Article 7, which says, 9 out of the 13 states, when they approved it, the new Constitution would go into effect between them. In essence, these 9 states would form this new nation. Now, we had 13 states at that point. So do the math. What are the other 4 states going to do? They're hanging out there in the wind now, right? Because the first 9 to ratify, well, they've abandoned the Articles of Confederation. They deliberately violated it and came out with a whole new document. Well, one by one, they eventually ratified, including Rhode Island. Rhode Island finally ratified it 14 months after George Washington was sworn in as president. Remember, George Washington came in, the Union only had 12 states. Rhode Island is hanging out there. What they really wanted before they were joined was the Bill of Rights. That's what Rhode Island is hanging out for. That's what they were waiting for. They wanted to get firm commitments on that before they would go along with this new Constitution. They got it. And eventually, Congress did add the first 10 amendments to the Constitution, which we now call the Bill of Rights, because that was the understanding and agreement between them. So Rhode Island ratified it. All 13 of those states did ultimately ratify that Constitution. But understand, they changed the ratification requirements. In one sense, they had to. Because those 13, the requirements of the Articles of Confederation said 13 state legislators had to approve it. It was such a massive document change, a whole new constitution, okay? And powers were shifted from the state to the federal, national government really. They didn't view the state legislators as having the authority to approve it. It had to be approved by the people. So what they did was, and you actually read this, in this new ratification method, Article 7 of our current Constitution, was they told the states to form state ratification conventions. Separate from their legislators, they would form a whole new body for a one-time purpose, okay? And they actually had representatives from around the state. Let's just give a number, let's say 4 per county or something like that. The state ratification conventions typically had like 400 representatives at it, 400 people. And they would then be the spokesman of the people and actually pass this document. They would vote on it and they would ratify it. And it went through all 13 states and was actually ratified. That's what they did to, what do you want to say? It didn't require state legislative approval. It required a people's approval. That's how they did it at that point. They didn't have a statewide vote, or something like that. They didn't do it that way. They had these state ratification conventions. Here's the key thing. It worked. It worked. new ratification method, and it's stuck. Now, today, can you imagine what happened today? I'm a retired IT guy, and I understand this. I know a lot of my training on this, or education from it, came from the John Birch Society, because they had put out a lot of information on it. But if I know this, do you believe the delegates to the convention today wouldn't know this? You bet they would know it. They would know it within the first half day they were there, that they could come up with a whole new document, a whole new means of ratification, and it would be legal, ethical, justified. It would be proper. And believe it or not, I support that idea. It's why it makes it so dangerous. So I don't want to implement that right now. I don't think it's wise in the tenor of our nation today. But they could actually do that. You know what might be popular today? This may well go over today. Can you imagine a convention coming out and saying, we want to propose a whole new constitution, a whole new means of ratification. We want to have a national vote, and we're a democracy now, so majority wins. 50% plus one. How much impact do you think Oklahoma would have on that? The large population areas would dominate. The thing is, how many people today, I'm not talking about a lot of the members of our county Republican parties that are really these videos are geared towards, okay? I think people understand the difference. But how many people today in America say we're a democracy, and they don't even understand the idea of a democracy versus a republic? They can't even articulate the difference between what those two words mean. How many people today believe we're a democracy? Because all the news in our education, NPR, and our public educational system, so many people believe that. I fear they would assent to the idea of a new means of ratification and have a majority vote. And before you know it, this very document, which has held this nation together for 250 years, given us the oldest government in existence in the world today, could be significantly altered. And I would dare say, in harmful ways. All the checks and balances and safeguards, our founders built into that. I encourage you to read Madison's notes. You'd be incredible. You'd be amazed at the amount of detail they went through to ensure this document was written the way it was. And all the various protections, not just three branches checking each other, but up and down the various levels, how different positions were elected and selected. It all made such a difference. If we do anything, we need to go back to the original. I'm not talking about slavery, bringing slavery back in. That's just a silly argument. Of course, we need to keep slavery out. But if anything, we need to go back closer to the original Constitution, not in this age of progressive era, move forward, whatever that means. So for this reason, I encourage you, we do have problems to solve. Having an Article 5 convention is not the solution. It's a very dangerous path, and there's no way to make it safe. Okay, just so you know. Not from those with ill intent towards America. Oh boy. You have any questions on that, please reach out to me. But I encourage you to get in touch with the state legislators. Okay, I do visit with them, and this is a primary topic why I visit the state capitol. And I do talk to them, but they need your support. They need your support to not have a convention, okay? And the reason I say that is because the Convention of States, private organization, is very well funded. Millions of dollars each year. Love to know the source of their money, okay, and what's going on and who's actually funding them. They're going around the country. They go state to state, and they put on their effort. And their own members who go there and they attend and they walk the hallways and say, we need to balance the budget. Convention's the way to go. I'm hard pressed to get them to look at the realities of this document. They're my neighbors. Okay, right? Just like your neighbors. And I'll greet them with a smile at the Capitol as they assemble and overlook the chamber, well, let's say with this last year where the Senate was meeting. And it's kind of like a prayer that I'll have, mimic our Lord. Lord, forgive them, for they know not what they do. They just don't understand the risks. Some do and want to assume it. Some do. I think the majority don't. So please help in the effort. Talk to your state legislator about it and encourage them to not support the Convention of States. What we need to do now is rescind our current application that's out there now. The current application out there now, it passed a number of years ago, I think it was 2016. Legislators at that time did not have the information I just gave you. That research had yet to be done and brought out. We now have this information, okay? And it's just a matter of getting in front of the right people. So please do talk to your state legislators about it. If you'd like to reach out to me, please do so right through this channel, all right? And please like and subscribe as well. And let's see, any comments?
Oh, the only comment I have listening to what you have said is, why fix something that isn't broken?
Yeah, our Constitution is not what's broken.
Just have our 250th birthday party for America, or birthday celebration, and it's still the greatest country in the world.
Yes, it is. And the mantra there is we don't need to change the Constitution. We need to follow it. Is really what we need to do.
Right.
All right, and we're drifting further and further away from it, as we reinterpret it, because it's a living document, whatever all that means. Right. All right. Thank you very much for your time. Next week we'll carry on. We have more interviews. Thank you all.